Alright, so now I would call all the panelists up on the stage and take the charge. So I'll start with the moderator, Mayank Singh Thakur, Senior Partner MASIN. Then our first speaker, Mr. Puran Kumar, Head Contracts Administration and Claims Management, Larsen & Toubro. Welcome, sir. Then we have Mr. Vinodkumar Menon, CEO, IRB Infrastructures. Next we have is Mr. Stephen Lim, Arbitrator and Barrister, 39 Essex Chambers. Next we have is Mr. Sandeep Upadhyay, Managing Director, Infrastructure Advisory, Centrum Capital Limited. Next we have is Ms. Kanika Arora, Partner from MRP Advisory. So before wasting any more time, I would like to hand over the stage to Mayank. Over to you, Mayank. Thank you.
Thanks a lot, Pallavi. A very good afternoon and warm welcome to all ladies and gentlemen present here. Allow me to set the stage for the significance of today's topic. Important aspects of construction law, Indian perspective. I am Mayank Singh Thakur. I am your host and moderator for today's session. We welcome all our panelists and speakers who are industry experts and bring unique perspective and expertise knowledge to shed their light on today's topic. But before we start our session, I would like to introduce our distinguished guest. Our first panelist is Mr. Puran Kumar. Mr. Puran Kumar, MTech from NIT Kurukshetra, is a seasoned professional with 28 years of experience in construction industry, predominantly in the domain of contract administration and claims management of infrastructure sector. He currently holds the position of Head Contracts and Claims Management for Transportation Infrastructure IC of L&T. His expertise includes handling construction contracts, project management, dispute resolution, complex legal framework, risk mitigation, building strong client relationships. Mr. Puran has actively participated in various conciliation and arbitration proceedings, mediations, and negotiations, contributing to fair and efficient conflict resolution in construction sector. Mr. Puran is passionate about training and raising awareness in contract administration and claims management, and he frequently speaks at industry events. Welcome, Puran sir. Our next panelist Our next panelist is Mr. Vinodkumar Menon. Mr. Vinodkumar Menon serves as a whole-time director and chief executive officer of one of the investment manager of IRB InvIT Fund, India's first infrastructure investment fund. Mr. Vinod holds BTech degree in civil engineering from BHU Varanasi and brings with him 35 years of experience in infrastructure development and management. He is also well versed in infrastructure related disputes. He has several decades of experience in litigation and arbitration, offering advice and handling range of commercial disputes. Previously, he held the position of President Business Development at the sponsor IRB Infrastructure Developers Limited. Additionally, he currently holds the role of Vice President at the National Highway Builder Federation, a non-profit organization. Welcome, Vinod sir. Our next panelist today is Mr. Stephen Lim. Mr. Stephen Lim is an arbitrator and barrister, having over 100 appointments as presiding sole, co-arbitrator and emergency arbitrator seated in Singapore, England, USA, India, South Korea, Thailand and Vietnam. He is also a member of English and Singapore bars. Mr. Stephen has extensive experience in ICC, SIAC, ICDR, SCMA, KCAB, UNCITRAL rules and ad hoc cases involving Indo-Pacific jurisdictions and further, and involving Indian parties seated in and outside India as both arbitrator and counsel. Mr. Stephen has earned commendations such as the perfect arbitrator, extremely effective arbitrator, and an outstanding up-and-coming superstar. He is known for his competence, confidence, ability to manage cases effectively while providing fair and impartial hearing to all parties involved. We welcome you, Stephen, sir. Our next panelist is Mr. Sandeep Upadhyay. Mr. Sandeep has more than 20 years of extensive experience in investment banking and corporate finance advisory, focused on infrastructure, energy, and logistics sector, with exposure of leading private equity, merger and acquisition, public market, project finance, structural debt and finance restructuring, insolvency, and bankruptcy process. Mr. Sandeep joined Centrum Capital Limited in June 2008 and presently serves as Managing Director, Infrastructure Advisory. He is an alumni of XLRI Jamshedpur and recipient of the prestigious Distinguished Alumni Award from the institution for his contribution in the space of infrastructure financing. Prior to Centrum, Mr. Sandeep has worked with SBI Capital Markets and ILNFS Transportation Network Limited. His current role as a senior coverage banker, Mr. Sandeep is responsible for sourcing and executing fundraising and corporate finance advisory deals across transportation, logistic, conventional and renewable energy sector. Welcome, sir. Last but not the least, our next panelist is Ms. Kanika Arora. Ms. Kanika Arora is partner at MRP Advisory, who actively contributes to firm's arbitration team, engaging in domestic and international commercial arbitrations, mainly in construction, energy and infrastructure sector. Ms. Kanika holds experience in high courts, NCLTs and legal due diligence. With Indian law qualification, she holds LLB LLM in oil and gas law from University of Reading, UK, and a doctorate in business administration from Swiss School of Business Management. Ms. Kanika has been shortlisted for Dubai International Arbitration Center's 40 Young Practitioners Group, Forbes Top 100 Lawyers in India 2022, and Business World's Top 30 Under 30 Lawyers in India 2022, and also an associate to CIRB UK. A warm welcome to all of our panelists. Now, let's begin the session. But before diving deep into the discussion, allow me to set stage highlighting the significance of today's topic. Construction law in India is a complex and ever-evolving landscape that significantly impacts two aspects of our industry. One, construction industry, second, infrastructure industry. As we discuss today, we aim to highlight both challenges and opportunities, providing you with valuable insights into navigating the construction law. Construction disputes, whether arising out of delays, budget issues, financial issues, or regulatory conflicts, can have far-reaching effects. They can have impact on project timelines, project budgets, and even to the reputation of the stakeholders. Understanding the dynamics of construction law is not only duty of required for legal professionals. It is also required for all involved in the construction project, be it project managers, contractors, developers, and even government authorities. India is eyeing to become third largest economy, and construction sector will be the biggest contributor in it. Resultantly, a lot of investments are happening in the construction industry, and disputes are unavoidable where investments are involved. So, key to success is fair resolution or early resolution of the disputes. And definitely, India is becoming a breeding ground for construction disputes, and we all know about the overload on our judiciary. Thus, the alternate dispute resolution becomes very important. Let me read out the latest annual report published by Ministry of Statistics and Program Implementation. In India, as of 1st December 2021, there were 1,679 central sector infrastructure projects on ministry's monitoring. Out of these, 541 projects are running behind time, with a time overrun ranging from 1 month to 324 months. Original cost of these projects were USD 111 billion, which is now anticipated to be 148 billion USD, which is an enormous increase of 34%. So first and foremost reason of all these cost overrun is time overrun. Now, cost claims involved in the construction disputes are humongous. And prime reason for this is time overrun. So to resolve such disputes, the primary question that needs to be answered is who is responsible for delay? And to answer that question, we should know the answer, who caused delay? The parties are increasingly using services of international arbitration institutions, and India is moving forward for institutionalizing its own arbitrations. And there are various arbitral institutes in India which administer both domestic and international arbitration. Some of these are International Center of Alternate Dispute Resolution, ICADR, Indian Council of Arbitration, ICA, Delhi International Arbitration Center, DAC, and Mumbai's own Center of International Arbitration, MCIA. Our esteemed panelists today are leading experts in their respective domains, and they offer expertise and their knowledge to us today. We will today deal with delay dispute resolution systems, impact of external factors like COVID-19 and geopolitical events. We also see the role of third-party funding today in our panel discussion and legal implications of the unlawful termination. But before we begin our session today, I request all our audience to be ready with your questions for a Q&A session after our panel discussion. So let's get started. So my first question is to Puran sir. So sir, there is a clause 20 in FIDIC which consists of time bar. It says any party which is facing delay has informed to other party within 28 days of coming to the knowledge of such delay or such delay occurring. So my question to you is, from your experience, do you find these clauses too stringent for contractors to comply?
Good afternoon. Yeah, I find it very stringent, particularly in India. Please believe me, we do not administer the contract as per its terms. We get carried away by a lot of ego, a lot of emotions. And the manner in which the current infrastructure jobs are coming, it is so complex in nature. First of all, you have to handle the customer. And within 28 days, if you pile up with the notices of intention to claim, it doesn't go well. First of all, you please appreciate, ultimately the contract has to align with the law. Section 28 is very clear. The contract which is not aligned is void. Why to keep such a provision which is not aligned? And second and foremost is, there are situation arises. I will give an example. Say suppose some change of scope provision comes. Some additional work has been ordered by the customer that you want to execute. First and foremost, your requirement will be to get paid for the additional work which you do. But definitely it will have some time and cost impact. Please appreciate if you also start asking and notifying the customer the impact of additional time and cost. I am 100% sure with your experience in this country, you will lose even the basic cost of the work which you are going to do additional. So my experience has been it is too stringent. I would suggest that it could be modified to a provision wherein your right could be limited to the determination made by the engineer who is independent to the project, might have been appointed by the employer. So instead of putting such a stringent condition, it can be modified. In fact, to be very honest with you, it's not only stringent for the contractor, but for the customer also. Even if the situation arises wherein he wants to settle and make payment to you, it becomes very difficult for him to have the paper in line with that because the contractor might not have been able to serve the notice upon within the time. Then his hands also become tied. So my suggestion would be modification, and it is definitely stringent. Hope I have answered the question.
Definitely, sir, you have well answered the questions well. And it was really nice to see and hear your thoughts on this. So, continuing on the same line, my next question is to Mr. Vinodkumar Menon. What are the significant issues that commonly give rise to the disputes in BOT PPP road projects, and how do you address challenges such as land availability, COVID-19, and contract clauses limiting claims in Indian road projects, particularly in arbitration proceedings, sir?
Sorry for that. Good afternoon to all. I think this is the most pertinent question with respect to disputes in India. as Mayank Singh has already told in his opening address, that time overrun and cost overrun are the most important and most difficult tasks to be answered or responded in any dispute in a construction contract. As far as my experience goes, or all of you guys, so whoever is there in the infrastructure industry, the major issue in any road project is the land availability. Because unless you have land, you cannot start the construction. So land availability is the major issue. Then there are numerous approvals required for any road project to even begin. And those are land acquisition is the major, and second is the environmental and forest clearances. Then if it is close to the sea, there are CRZ clearances, and there is an umpteen number of approvals required, which the client is supposed to take before, to have these approvals in hand before even going for the bidding. That is what the model RFP or model concession agreements requires them to do. But as easy as it is to be told, it is to be stated, it is very difficult to be done, because all these land acquisition issues are connected to the local people. To the local people, it is difficult to control. So all these clients find it very tough to hand over this land to the concessionaire or the contractor. So this is the major issue which happens in disputes. Now, as far as arbitration is concerned, it goes within the boundaries of any contract. Now, boundaries of a contract tie up the arbitrators to decide upon any issue. So land acquisition, if it is an issue, and the client tells that publication of some 3D or 3 whatever gazette publication is issued, so on paper the land is available. But when you go to the field, you find, more often than not, you find that the amount of land, the quantity of land available as on paper, it comes to around 70-80% of that much. And for the balance, basically 80% of land has to be given at the appointed date. Appointed date is a commencement. So 80% has to be handed over, but they have it on paper, 80%, when they give the appointed date. But when you go to the field, it is not so. Maybe around 55 to 60% only. So that is the starting point of the dispute. So this is what the panel of arbitrators and the councils who are arguing for the matter deal with. Then the other issues are, of course, the environmental clearance and other issues. They are dealt with as per the contract. But as far as land acquisition is concerned, this is the first and the most major aspect which is arbitrated in front of the tribunal. Thank you.
Thank you so much for your answer, sir. But then definitely you have thrown a good light on land issues that give rise to the disputes. But one thing I want to understand from you again, sir, a follow-up question in fact. How COVID-19 circulars by government on giving time for the projects have been helpful in road projects?
So the question on COVID was bound to come.
Of course, sir. We all are suffering.
We are all fortunate to be, to have beaten COVID and be here. So COVID is such a rare occurrence in the lifetime of a human being that nobody could have even imagined or gauged what would be the effect of COVID on anything, any aspect in life, including infrastructures development. So for COVID-19, when it happened, the Ministry of Finance immediately announced the relief. That was a great step taken by the government, that they told that at least 90 days, minimum of 90 days of extension to the construction period or concession period in case of a BOT contract would be given by the government. So this was a relief and which was in line with the provisions of the concession agreement, but this was just a relief given by the government. But now this relief has been taken as sacrosanct by the clients and say that this is all that we will be giving. But, and the question of political and non-political event, that is a very important thing in COVID. You never, COVID-19, whether it is a political or non-political, has not yet been solved by the even the courts of India. It is still running. But as far as the concessionaires are concerned, it is a political event because, of course, epidemics are covered under non-political event. Non-political event means earthquakes and acts of God. So it is taken as an act of God by the clients. But the traffic movement and loss of toll collection, or the toll plazas being stopped, were all ordered by the government of India or government of state governments. So this particular directions by the state government have superseded the direct effect of COVID. It was not due to the impact of COVID that the traffic reduced, but it was due to the order or the directions by the court, direction by the government, that this stoppage. That is why the contractors are fighting for a political force measurement. Thank you.
Thank you so much for your answer, sir. So we just heard two bigwigs from industry. What are the major reasons of disputes in India in construction sector? But we also want to know what is the international perspectives of various construction dispute in India. So my next question is to Mr. Stephen Lim. So Mr. Lim, as a foreign practitioner of construction law, how do you see Indian construction dispute market?
Thank you very much for that question, Mayank. As you said in your introduction, Mayank, there's a tremendous amount of infrastructure work that goes on in India. I have seen myself a number of India-related construction cases involving construction projects in India. And also, I'm also seeing increasingly construction projects involving Indian parties, particularly Indian contractors outside of India. And I'm quite impressed by how Indian contractors go all over the world and do work in far-flung places that then end up in arbitration in Singapore, which is where I see them. So I see it as a very vibrant sector. If I could just make some comments about some differences that I notice about how construction disputes are dealt with in India as opposed to internationally. And it's not specific to whether you have an Indian party or not, it's how things are done in India. And it's also dependent on where the arbitration is seated. These are points which I've picked up having sat in India as well, in construction cases. One of which is how you deal with expert evidence in construction. Expert evidence is very, very important in construction cases. Many construction cases turn on technical matters, and the tribunal would rely on the expert to give evidence, since quite often the tribunal is not necessarily expert in these particular technical fields. One thing that has gained a lot of currency in international arbitration is witness conferencing, where you have the experts sitting in a conclave and being examined together, dealing with issue by issues. And I understand this is not common in India. And I've noted that, and I think that that's something perhaps you may want to consider, because I personally feel there's a lot of advantage in having expert evidence in witness conferencing. It helps bring out the issues that need to be resolved more clearly and focuses on the issues rather than having cross-examination of each expert individually. Another aspect that I have, and this is a little bit progressing a little bit more generally about how arbitrations are heard, is not too long ago I sat, this is actually during the pandemic, or the pandemic intervened, and I was supposed to be sitting in Delhi, but because of the pandemic we had it virtually. It was a construction dispute in India under Indian law, had an international element because it involved international contractors with an Indian employer. One of the issues that came up that was very obvious as in the initial pleadings was that there was a question of time bar. The employer brought the claim against the contractor, and the contractors, or it's actually a consortium of contractors, and the contractors' defense was a question of time bar under Indian law. It became apparent to me as the case developed, and I was sitting with two retired Indian judges, so they knew how things are done in India. It became apparent that the legal case, it developed a little slower than it does internationally, in that the practice, and I'm told by the retired Indian judges, that the practice in India is that the parties develop their legal case, present the legal authorities closer to the hearing and not necessarily as the case progresses. So we knew the case of time bar was raised, but it wasn't clear exactly what the case on time bar was. And we had put in the procedural timetable, when I was chairing this case, I had put in the procedural timetable a point at which, after the pleadings, for the parties to bring preliminary issues if they wanted to, thinking that time bar may be one of the issues they may want to raise and have us decide earlier rather than later. But when it came to that point, the parties didn't raise any preliminary issues. So the case then moved all the way through to a final hearing. At the final hearing, it became very, very apparent, because by that time, the time bar defense and both sides' arguments on time bar became much clearer. It became apparent that it was a very, very crucial point. And in fact, in the award, in the end, the case turned on time bar. We found the case was time barred. And I sat back at the end of it thinking, if we had dealt with this a lot sooner, we might have saved a lot of time. And the parties had the choice to do so. We had put in the procedural timetable a point for which to raise the preliminary issue. They didn't. If we had understood the case a little bit better earlier, we might have given the parties a prod, but we didn't understand the case. So there was an interesting experience for me in seeing how arbitration is done in India, and I wanted to take this opportunity to share my views on this in this forum. Thank you, Mayank.
Thank you so much, sir. And when Mr. Lim was advocating about hiring experts in an arbitration, I was listening, hire MASIN in an arbitration. So, having heard international view on Indian dispute market, in India, the major point of concern currently is the escalation claims. See, we have seen a lot of escalation claims that has been arisen mainly due to geopolitical events of Russia-Ukraine war or similar, and definitely COVID-19. So, my next question is to Kanika. So, Kanika, could you share your legal experiences in handling escalation claims arising from events such as COVID-19 and Russia-Ukraine conflict and affecting commodities market in the construction industry? Additionally, what is the legal standing under the Indian law for such types of claims?
Thanks for the question, Mayank. I think this question is the most trending question for all contractors as of today, even though we are 3 years forward from the lockdown. I feel this is the most prevalent question for all the contractors. Yes, the kind of work that my firm is engaged with is morely on behalf of the contractors than the government. So this is something which is a part of probably every arbitration mandate that we're currently handling right now. And the reason why it is so relevant is because there is no right answer as of now. And the biggest reason for that is because a lot of judgments are still to be pronounced. They're still pending, as the fellow speakers also had suggested. When we talk about, the larger bracket of force majeure events, and the recent examples being COVID-19, the Russia-Ukraine war, it's led to consequential effects which have disrupted the global supply chains. For example, the prices of steel shot up drastically, which was not at any point contemplated when the parties were signing the contract. Yes, contracts generally take into consideration certain fluctuations in prices of input commodities, but such a drastic and significant increase was probably never, contemplated by parties at the time of signing of the contracts. So much so that even though the contract provides for certain fluctuations and certain mathematical formula are given to, come to some kind of consensus between the parties, what it seems in 2 or 3 cases that we have dealt with is that even those mathematical formula could not capture the cost that was incurred by contractors. It went beyond the formula, and the dispute in primary comes to the point that, look, the contract provides for a formula, we need to stick to it. And the contractor then has to establish and justify as to how this formula is not actually going to compensate the cost, and we need to go beyond it. Interestingly enough, when such claims are actually submitted to the employers or before a tribunal or before a court, I think India has come a long way for the tribunals and for the courts to understand the technicalities involved with such disputes. It was, I think, in a recent judgment in July 2023, I think it was a Delhi High Court judgment or a Supreme Court judgment, if I'm not mistaken, where the court actually went into the details of, what kind of a mathematical formula companies must use to justify their claims. And it went on to suggest that you can't just pick any mathematical formula out of thin air and justify your claims. It has to be a formula that does not fundamentally change the basis of your contract. So whether it may be, claims justified by force majeure eventually under Section 56 of the Indian Contracts Act, when we talk about frustration of the contract, I think it was a very broadly interpreted term when we were in the position of COVID-19 and Russia-Ukraine war, which, if I have to suggest a single judgment to kind of understand what the position of courts when it comes to force majeure events, it would be Justice Nariman's explanation in the Halliburton case, where he goes on to explain how the courts must interpret force majeure events. Because what was happening at that point of time is there was a Bombay High Court judgment as well, where contractors were just abandoning projects because of the lockdown. And the courts went on to say that just because there is a lockdown doesn't mean you abandon the project and you're relieved of your responsibilities. It has to make sense. There has to be a chain of causation which needs to be proven. So in a way, I think not just the courts, but even the government bodies, PSUs, are very mindful about such circumstances. I think, at least for us, we've seen a good positive response from PSUs, where they take the initiative to understand these matters. The courts are being, by way of notifications, identifying, acknowledging the circumstances that we are in right now and taking necessary steps to protect contractors and future projects. But I think when it comes to legal standing as to price escalations, force majeure events, consequential effects, I think we're still 2 years away from having a concrete answer.
Well, definitely we don't have a concrete answer, but you have cleared the air quite a lot. So definitely we have understood how Indian courts and Indian legal system is dealing with this situation. But definitely my next question is to Mr. Lim again. So sir, coming back to you, what has been the position of Singapore courts on COVID-19 related claims for additional cost in construction contracts? And how should claims for unlawful termination arising out, maybe for any reason, COVID-19 or any other reason, are addressed in Singapore?
Thank you, Mayank. I'll take that question in 2 parts. I'll deal with the COVID-19 claims and how that's dealt with by the Singapore courts first, and then deal with claims for unlawful termination separately. There's no doubt that COVID-19 was a very significant impact on construction projects in Singapore, just as in everywhere in the world. A lot of projects have been delayed significantly because of COVID-19, and also the cost of construction during that period shot up incredibly as well. Having said that, there hasn't been a flood of COVID-19 cases before the courts. I think there are a number of reasons for this. One is Singapore, just as in India, came up with a number of regulations to deal with COVID-19 as it was ongoing, including giving extensions of time to projects and prohibiting claims to being brought and contracts being terminated during that period. So that ameliorated to some extent the havoc that COVID-19 could have wreaked in the industry. There's also the question that in Singapore we have adjudication as a mandatory adjudication for projects. So many cases get adjudicated and don't end up in court. And also during the COVID-19, a special adjudication was introduced called assessment, with assessors rather than adjudicators, but primarily the same thing, dealing specifically with the impact of the regulations put in place for COVID. There are, though, a number of court cases which interestingly deal with aspects of the contract that relate to COVID-19. There was a case in 2022, so before we were completely out of the restraints in COVID-19, where the court had to deal with the question of the meaning of force majeure in the standard form Singapore Institute of Architects contract. Most construction in Singapore of buildings takes place under the Singapore Institute of Architects contract, so it's a very, very widely used standard form. And that contract had, under the extension of time clause, one of the grounds being force majeure, which was not a defined term in the contract. So the court had to determine what force majeure meant. And what they said was that force majeure was a radical event that prevents the performance of the relevant obligation, not merely making it more onerous, and which is due to circumstances beyond the party's control. And the court found that this could include COVID-19. So there was a recognition on the part of the court that COVID-19 could, in certain contracts, looking at the definition of what's provided in the contract, in this case of force majeure, that could include COVID-19. There were also cases in the courts on the question of whether COVID-19 could constitute frustration of the contract, as in legal frustration of the contract. These cases involve lease agreements, not specifically construction contracts, but one can extrapolate from that to see how that might be applied in a construction case. The lease, in those two cases involving lease agreements, the court found that the lease agreements were frustrated because of the intervention of COVID-19. And extrapolating this to the construction context, it is possible, depending on the context, of course, and the terms of each contract, to see whether COVID-19 could have rendered the contractual obligations of the parties, making it impossible for it to be performed or radically or fundamentally different from what had been contractually agreed. And there is some precedent for this, not for COVID-19, but much before COVID-19, but one can see how, if the courts are willing to accept that COVID-19 can frustrate contracts, how this can be applied in the construction context as well. That about close to 10 years ago, Singapore had a crisis in the construction industry as well, because we import most of our sand for construction from Indonesia. And Indonesia suddenly put in place a ban on the export of sand. So there was a real lack of sand for construction in Singapore. And a case did come before the courts then, and the courts found that actually there was frustration, because what the parties had contemplated was the use of Indonesian sand for the project, and the sand ban was an unforeseen supervening event. So one can see that no case has specifically come before the courts dealing with COVID-19, but the courts have, in certain circumstances, depending on the facts of the case, seen that if the performance of the contract is to be radically different, and the court gave some guidelines in this, that while an increase in cost in its own would not necessarily be a frustrating event, but an astronomical increase might, and certainly construction costs went up astronomically during COVID-19. The court also gave guidance that literal impossibility is not required for frustration, but the unavailability of a particular source from which the subject matter of the contract was derived could frustrate the contract. And if COVID-19 had disrupted certain supplies, critical supplies, that possibly could also then come within the question of frustration. So we have seen the Singapore courts being positive in that sense to giving relief under contractual grounds for COVID-19 cases.
Thank you so much for your answer. Definitely we have seen COVID-19 has brought forward so many disputes and so many difference of opinion between various parties and stakeholders of a project. But definitely one more thing we are dealing with in day-to-day life after COVID-19 did happen prior to COVID-19 as well, but after COVID-19, that is unlawful termination. So my question to Ms. Kanika here, could you explain the legal position of Indian law regarding specific performance in cases of unlawful termination in construction contracts?
Yes. So, as far as the Indian jurisdiction is concerned, getting a grant of specific performance is extremely difficult once a contract is terminated. If we talk about the ambit of Section 9 petitions for arbitrations, where we're looking for a number of times it's happened in court that parties would make a claim for specific performance under a Section 9. And the courts always have this view that a Section 9 is for interim measures and it cannot actually compel the parties to reinstate the contract. An interim measure cannot be reinstatement of the contract. But then again, you know, when we talk about the Indian jurisprudence, we're talking not just about Supreme Court being the ultimate authority, we're talking about different high courts having different opinions. And this is one such case. This is one such issue where we see the Delhi High Court being very strict about permissibility of specific performance under Section 9. But we've seen instances of Calcutta High Court and Bombay High Court where the judges have in fact allowed it. But I feel like the cases that we have read and been a part of, I think in cases where the damage is so tremendous by that termination that it cannot be compensated monetarily, and reinstatement of the contract is the only way where the party would not be aggrieved, in this case would be the only case where the courts or the arbitral tribunal would consider specific performance of the contract at an interim stage. But otherwise, in our experience, specific performance once the contract, even though has been unlawfully terminated, is something very difficult to be granted.
So that's very enlightening and that's good to hear from you. But taking it forward, that not just unlawful termination and disputes arise on very other reasons as well. And the biggest prime reason, as I said it during my opening statement, that delay has been the biggest reason of disputes. So coming back to the industry bigwigs, so my question to Mr. Puran is, so could you elaborate how do Indian arbitrators typically resolve delay disputes and whether they commonly involve delay experts in their decision-making process? And one more part of the similar question, the question very similar to it is, so do you think DAB is a suitable method for such disputes to be resolved?
Unfortunately, in India, so far arbitrators have not taken the help of the experts. Now, as Mayank has told, even other panelists have also said, the major portion of the dispute arising in construction, in infrastructure, is arising out of the delay and disruption. Even I also, what bucket of claims I have, the biggest one is delay and disruption. And it is very important for an arbitrator to adjudicate upon whether delay has been caused by which party. Either it can be caused by the contractor, or by the authority, or by the force majeure event. Force majeure event, you may consider that it is both the party, either party has to bear their own cost. But definitely, if you are not able to demonstrate the delay has been caused by the other side, you are not entitled to the compensation. To arrive at this decision, an expert is definitely required. But so far, as I said in the beginning itself, unfortunately in India, has not yet come to that stage wherein arbitrators are taking the help of independent experts. Yeah, parties have been appointing experts from their own and they testify before the tribunal and try to demonstrate that delay has not been caused by the affected party. But it is up to the tribunal to what extent they will take cognizance of the fact presented before them. It all depends upon the cross-examination. But I am very sure that the manner in which India is going ahead in infrastructure and international market is also catching up. We have opened the construction industry, infra particularly for the international players. So international only contractors are not coming, experts are also coming. So I am very sure in coming days we will see arbitrators also taking the help of independent experts, particularly for analysis of the delay and disruption. The second question, Mayank, I think what you are asking is DAB. I don't have a good experience, to be very honest with you. The intent is very good to have DAB. Mostly these claims are technical in nature in infrastructure sector, in construction industry. So the basic purpose of the DAB is that you can appoint when the contract commences. Very strict regime in the contract within 90 days of appointed date or within 90 days of commencement or the moment you sign the agreement, within 90 days you can appoint a board. Each party will appoint one and both those together they will appoint the presiding one or the chair. So they can visualize not only from the document, they can be very much party to every event which is causing delay, disruption or any claim is arising because of change of scope. But the problem is in India here that the one party, all big contracts, it is the other side is the government. And the officers are always afraid of implementation of the decision or recommendation of the DRB or DAB, whatever they say. So they show reluctance in implementation unless and until it is binding or order of a court. And all of you must be aware to the extent you might have got exposed to DAB provision. It is not binding on either of the parties. It can very well challenge in arbitration. I will tell you my experience dealing with national highway projects in the beginning, starting from you can say 2000 to 2013-14 till the time new regime came. Every contract of national highway had the provision of DAB and you will be surprised success rate was 3%. Only 97% of the DRB recommendations were challenged. Now again NHAI is trying to implement that. But it becomes another layer, one more. Even DFCC in railway, they are also trying to implement it. But again there is a reluctance to honor the recommendation. I have seen the recent trend in high-speed rail. That also we have a couple of jobs wherein they have started with very positive note that they have started implementing the DAB, but still we have to see how do they deal with when it comes to the delay and disruption claim. Initiative is good, intent is good, but somehow as it lacks the teeth for implementation, it's not so successful here. But I am hopeful.
Thank you, sir. We all are hopeful, and as you bring forward NHAI in your answer, yeah, definitely we are talking about the biggest litigator in the country. And we have with us Mr. Vinodkumar Menon. So, sir, my next question is to you. IRB is one of the biggest concessionaire in the road sectors. So, what are your views on Sarod and other schemes for faster and efficient dispute resolution implemented by NHAI? And are these schemes successful?
Yeah, definitely. Sarod has been successful partially. Sarod, I will just explain what is Sarod first. So it was formed by NHBF, that is the National Highway Builder Federation, that is the concessionaires body, contractors body, and NHAI, National Highway Authority. They formed a body registered under the Societies Act and formed a kind of institutional arbitration body in which they would select the panel of arbitrators and the disputing parties may select those arbitrators and form the tribunal for settlement of the disputes. So it was started in 2012 or 13 with all good intentions and to have an affordable cost will be less or cost will be optimal and time. So for that this Sarod was actually established. But with the time the panel of arbitrators bothered the National Highway Builders Federation members and they were not satisfied that the issue was that not many judges were there in the panel, the retired judges. Only technical members were there in the panel, with very few judges. So this was a problem for the quality and quality of arbitration, because interpretation of a contract, interpretation, legal as well as contractual interpretation, would be more effectively done by the judges and not the technical experts. So the quality of the tribunals somewhat reduced with the period of time. And another aspect was that the Builder Federation felt that not many suggested members or the arbitrators were included in that panel. Obviously, NHA had being the dominant partner in that's Sarod. So, but Sarod is managing well. Sarod is doing its job, but in a limited fashion. In any case, after 2016, when the new model concession agreement came, this Sarod was kept mandatory. So obviously, you don't have a choice, so it has to be in Sarod. But we are, NHBF is trying its best to include some judges in the panel.
Thank you so much, sir. So L&T is also dealing with a lot of projects involving NHAI. So Puran sir, your quick views on Sarod and other efficient methods.
Yeah, actually we have reduced our exposure to National Highway Authority of India. So I have very limited exposure to Sarod, but whatever I have good. I mean, the first and foremost advantage is that definitely it is very quick. I am going to finish one arbitration within less than 12 months. And fortunately, I got a good Supreme Court judge as presiding, and other two also very qualified and learned panel of members. But as Menon sir has said, the biggest challenge in Sarod is that the panel, the manner in which NHI has made, although it appears as if it has been jointly made by NHI and NHBF, but it is going unilaterally, and it doesn't have a really wide range of arbitrators. That is the one challenge. But at the same time, I would also like to take this opportunity to bring forward what NHI is doing on a very large scale. NHI is also, before arbitration, they are settling the claims through Conciliation Committee of Independent Experts. They have formed 3 panels, 3 committees, and you will be surprised that they have disposed of about claim worth 45,000 crore, and the average amount of settlement is roughly about 34%. So roughly 15,000 crore of claim has been settled in last couple of years, and very efficiently. Their target is that to settle the claim within a period of 3 months, and some of the claims even we have settled in 3 months. Their normal time is 6 months. We have settled certain claims in 3 months. But recently in NHI there has been some slowdown. So this Sarod initiative, it will be really wonderful if they really have wider range of arbitrators, and this, if they continue to this settlement through conciliation committee of independent expert, I don't think any parallel system has been developed by any PSU or any government sector in the country. Thank you.
Thank you, Puran sir and Vinod sir, for your thoughts on Sarod. With this, we move to next topic of discussion today, third-party funding. Just to introduce, third-party funding in arbitration refers to the situation where an external party, not directly involved in the legal dispute, provides financial support to one of the parties, which is usually claimant, to help to cover the cost associated with the arbitration proceedings. The financial support typically includes legal fee, arbitration fees, and other expenses related to the dispute. In return, The third party funder usually receives the share of the proceeds if funded party is successful in the arbitration. Overall, third party funding in the arbitration is a tool that can provide access to justice, level playing field, and enable parties to pursue valid claims without being burdened by the high costs of arbitrations. It has become an important tool in the world of dispute resolution, particularly in complex and high-stake cases. However, it also raises the important ethical and regulatory considerations that need to be addressed to ensure the fairness and integrity of the arbitration process. So with this introduction, my first question to Mr. Sandeep Upadhyay. Sir, we have noticed that construction arbitration worldwide often involve third-party funding. You are involved in infra funding in India, and construction arbitrations world over are generally third-party funded. How do you see the evolution of arbitration awards or claim purchase in India?
Thanks, Mayank. So globally, as we know, this concept of third-party funding against the arbitration awards is fairly well established, largely driven by the developed nations. We've got Australia, UK, US, where this market practice in terms of getting a third-party funding by the likes of the Blackstones and the BlackRocks, and in fact, some of these long-term investors as well take a call. As far as India is concerned, we are at a fairly nascent stage. I think it will be fair to say that we are at a very, very early stage from that perspective. Global market, if that has been growing at little less than 10%, given that India's base itself is low, one could actually expect a much higher growth rate. Having said that, I think there is no formal endorsement from the government in terms of a statutory legislation being passed which is endorsing third-party funding. This, I think, is a major impediment. There is already a direction here, or the guidance has come from the government, that this could actually be a very large part of solving the problems that we have in the construction industry. We've already got stalwart from IRB and L&T here, and we know the kind of money that is stuck for large EPC players. So this could actually play a very, very important role in terms of bringing the much needed liquidity with the contracting firms. If you talk of clients like NHAI, and if I'm getting the numbers right, I think with NHAI itself, the claims, outstanding claims would be more than 1 lakh crore. And we all know NHAI, I think all our friends would agree, amongst most of the regulators, NHAI has actually seen a more progressive regulator, and with the kind of work that we are actually delivering in the road sector, I think it is very important that some of these agencies like NHAI actually come to the forefront in terms of resolving this matter. So from an opportunity point of view, I think the opportunity is humongous. From a legislation point of view, we need to do much more as far as India is concerned.
Thank you so much. My next question is to you only, sir. There have been instances wherein infra companies have been purchased through NCLT process primarily due to their large value arbitration. So you want to share your views on that?
Well, bankruptcy process when it was initiated 2016 was holding a lot of promise, and one is not criticizing IBC. I think it has gone a long way in terms of resolving, and it is not seen as a recovery process, it is seen as a resolution process. But statistics, 45% of the IBC cases have actually landed up into liquidation. So when you have recovery rate of single digit, when it comes to IBC resolving a process, the statistics actually states that NCLT may not be the most efficient process, or that may not be the segment where you would actually see the nature of claims may be bulky, but the probability of it getting resolved is less. And my take here is one should actually see companies in 3 categories, not just NCLT. In fact, there is a lot of resolution that is happening even outside NCLT, and that is what the government has been driving because the NCLT courts are essentially clogged. that is where I see that there could be a huge opportunity in terms of financing the or the claims which are stuck with the stressed companies. Because the healthy companies will not really need someone to come and fund their claims, right? It is the stressed companies or the companies into bankruptcy. Bankruptcy you have just discussed, the process getting resolved through NCLT. However, in the stressed asset cases, actually there are a lot of stressed asset funds who are wanting to take a call on litigation or arbitration awards which are stuck.
Thank you so much, sir. But then I would also want to hear out the Singapore perspective on funding. So, Sir Stephen Lim, my question to you: many disputes which are JICA funded have ICC institution, Indian governing law, and Singapore seated arbitration. So, what is the process in such arbitrations for challenging the arbitral award, and how are Singapore courts dealing with such challenges governed by Indian law? Sir, your quick views.
Thank you. Well, challenge of an award in Singapore is dealt with in accordance with the ancestral model law. That is Article 34, which I believe is the equivalent to Section 34 of the Indian Arbitration and Conciliation Act. So that's the basis for challenge. That's for setting aside an award. There's also the possibility of challenging a different way in that if an enforcement is taken on an award, you can challenge enforcement of that award. And that challenge also takes place under similar grounds in the New York Convention, which is the same as you'll find in Article 34 of the model law. The set-aside must be taken within 3 months of receipt of the award, and that's as provided in the model law. In Singapore, I should mention that there are 2 additional grounds. These are additional grounds in addition to what the model law provides for challenging an award, to set aside an award. One is that the award was induced or infected by fraud or corruption. The other one is where there's a breach of natural justice. So where the breach of natural justice has occurred in connection with making of the award by which has prejudiced the rights of a party. I say these are additional, although everyone would accept that if there was fraud or corruption, that infects the award. And the ground of breach of natural justice is also actually, if you think about it, in the model law itself, under due process. That's what a breach of natural justice is a breach of due process. There is an uptick of cases in which parties try to challenge an award on the ground of breach of natural justice, breach of due process. A number of these have been successful. It's partly due to the complexity of cases. Many of these cases turn on the ground of whether the tribunal had failed to decide an issue which has been put before them, or the tribunal decided an issue on grounds which are not put by the parties. So some succeed because of the sheer complexity of the cases, and some of these cases are in the construction space. The other question you had was, how does Singapore courts deal with challenges to Indian law govern arbitration awards? Well, as some of you may know, Indian parties are the largest foreign users of arbitration in Singapore and have been so for many years running. So a lot of Indian-related cases get heard in Singapore. Many of these are Indian law governed. I have dealt myself with cases under Indian law seated in Singapore and elsewhere. Singapore law has very common roots with Indian law. The Evidence Act, for example, we have in Singapore came to us via India at that time. So the law that we have is similar. There is no difficulty for the Singapore courts to deal with Indian law. In fact, when people study law in India, there's a lot of reference to Indian law cases because those are the roots to which we have the common law in Singapore. But in addition, we do have in Singapore the Singapore International Commercial Court, which has a number of foreign international judges on the court. And one of these judges is Justice A.K. Sikri, who's from India, who I know quite well. I sit with him in arbitration cases. So Justice Sikri is there as an Indian law expert to provide Indian law expertise to the SICC.
Thank you so much. I have been getting signals from my team that you're overshooting. But still we have time for a couple of quick questions. Sir, Sandeep sir, my question is, what are the challenges do you see in arbitration funding?
Well, very quickly, I think timeline to resolve, that is the biggest challenge. Quantification of these awards, that is the other challenge. And then you have, things like conflict of interest, which is resolvable. So in India, you have this law that as a legal entity, you can't be funding, an arbitration award. And then you have, two major challenges. One being the NOC coming from the lenders. So any of these companies, and we are not talking of bankruptcy here, we are talking of the companies which are stressed. Invariably, you will have to go back to the lenders, get an NOC, and only then you can think of monetizing your arbitration awards. And that, I think, is a major impediment today. Lastly, I think I was speaking to Stephen and he told me that in Singapore, you have a qualification criteria for the funders, which perhaps is also there in Hong Kong. In fact, in UK, there is a proper legislation to that effect. In India, we don't really have that. That brings a little bit of fluidity in the whole process. And that is another point which actually is very sticky from the point of view of quantification.
Thank you so much, sir. Kanika, your quick views. What is the position of Indian law on third-party funding?
I think as Sandeep has highlighted very well, is we don't have a regulatory framework on third-party funding in India. We did have the case of A.K. Balaji where the court said that that third-party funding is permissible, but just because you have announced it as permissible doesn't mean that it's actually going to take place, because for any such science, and I would call it a science because it is a science in itself, to take place, one must know the do's and don'ts of it. As Sandeep has again mentioned, that the only regulations that we have as of now is that one, advocates cannot be the litigation funders, and number two, the litigation funders as given in the Tomorrow Sales Agency case of the Delhi High Court very recently, that they cannot be parties to the arbitration and therefore the award cannot be enforced against them. It's all in a flux, to be honest. But nevertheless, I think it's a huge market for India, which is completely untapped right now, especially with companies entering into the CIRP process. So many of them have tremendous cases against government PSUs, strong cases on the merits of the case, but they're not able to pursue those mandates because of a liquidity crunch. And this is exactly where funders come into the picture. I think before we invite investors to India to actually start up the engine on this market, I think it's very important for us to get a regulatory framework in place for the same.
Thank you so much. I know we are running out of time, but I can't help, but I have to ask my favorite question here. To all the panelists, please answer within 15 seconds each. So, what is the importance of expert witness in an arbitration, and what can be done to increase the usage of various expert witnesses in the arbitrations, be it financial arbitration or construction arbitration or whatever? Your views very quickly, sir. Puran sir.
Already I have said that it is very important. The complexity to a problem which is coming forth nowadays, it is not possible for, particularly for judges, to appreciate the delay and disruption. Very much required.
And sir?
I would straight away take words from the mouth of Mr. Stephen that the technical expertise is required, because the arbitrators are mostly from the legal background who would not understand the technical aspects of each and every case. So it's very useful to have a technical expert witness in an arbitration.
Well, I think I've given my views on this already. I think it's critical. In most cases, in construction contracts, the expert evidence is critical. It's not so much the law, but what is the technical evidence on it? What can we do to increase the use, the utility of expert witnesses? I've mentioned expert witness conferencing. The other aspect as well is in how you deal with expert evidence, even before you get to that. sometimes you find that if you have the two experts giving their reports before they've actually had the chance to sit down and discuss it amongst themselves, they've taken certain positions, and it's much harder for them then to back down and to come to an agreement. What is most helpful to the tribunal that is largely ignorant on technical matters is the experts agree. So you tell the tribunal what are the technical issues and how they should be resolved. The tribunal will be very, very happy and grateful for that. And to encourage experts to agree and not take two diversion paths because they have taken positions early on in the process. One thing we've adopted in international arbitration is to have the experts meet before they actually give their reports. That's a trend, and I think it's something that's been quite useful in managing expert evidence.
Well, on the dais you have 3 engineers. I'm sure technical expertise actually go a long way, both in terms of giving you an efficient solution as well as qualitatively, defining a approach. So absolutely endorse the views.
I think from an advocate's perspective in any arbitration, I think for us, the expert evidence that is filed is probably a winning bet in our arbitration and the cross-examination that follows. Because if that goes well, you've pretty much won the case. So yes, it's critical.
So thank you, our panelists, for views. And the last question was meant to get the good answers about expert witness. So please do hire MASIN. MASIN is there as your best expert witness available. So we can take a couple of questions from audience if there are any. Yeah, I see a hand being raised. Can we have a microphone to sir?
Yeah, COVID pandemic is slightly different from any other force majeure event. Like for COVID pandemic, there are cases where 90 days to 180 days has been given for the first wave of COVID, EOT, extension of time. But the thing is, like after 1 month of lockdown, contractors were in fact made to work on the projects, maybe for essential works or continue in continuation with the main works. So thing is, like during that process of working, contractors have 3 events of compensations arising out of. I just wanted to have a view on those 3 aspects. One is escalation, which is already provided in the contract that escalation would be paid during the original contract period. And for delay events attributable to the employer. But force majeure is an event which is beyond, it's not attributable to employer as well. So the first thing is escalation as per the formula. Second is abnormal rise in prices during that period. And third is your underutilization. Since contractor is made to work immediately after the initial lockdown period of 30-35 days, is underutilization payable, is abnormal rise is payable, and is a normal escalation is payable under the contract.
Yeah, I would like to answer your question very quickly, and very pertinent question because it has been addressed by the panelist member also. The first and foremost is about the escalation, for which escalation is already provided. Once the customer has agreed to give you extension, normally all the contract employer in the country, they have allowed escalation as per the formula. Second, one most important, the Ministry of Finance, the circular which came and which was implemented on Ministry of Highways, they not only gave relief in terms of extension, they gave 2 more very big reliefs. One relief was that they allowed the payment as per the quantum of work which you performed during the COVID or even prior to that. It was not only, so in EPC contract where you were entitled to payment only as per the given methodology, unless and until you complete that quantum of work, nothing is paid. So milestone payment was envisaged into the contract, whereas they relaxed. And you will be surprised to know the highway construction which was constructed during the COVID, it has never been done. So maximum construction of highways was done during the COVID. Now to answer your second question, it was not the case that contractor was compelled to work. To be very honest with you, I am a contractor sitting in front of you. We happily worked because we got relief all the payment which was stuck because we were not meeting the milestone. The third and foremost benefit was given in terms of relief towards BG. All bank guarantee as far as retention is concerned was released. All cash retention was released. Bank guarantee is reduced from 10%, 7.5%, 5% to 3%. So all contractors have happily worked. And third question to you is about the compensation. So compensation, as Monica has also said, it has not yet settled in India, neither in anywhere else in the world. But you please appreciate, recently I was in on arbitration. Compensation you are entitled to only when delay has been caused by the other side. As a contractor, we have taken a position, it is not a force majeure event. It is an event because you compelled us to work. Or there is a, because of change in law. Because of implementation of change in law, so you are under obligation to reimburse. But recently in one of the arbitration where the Supreme Court retired judge was presiding, he said, your entitlement goes off the moment you accept those reliefs. Please appreciate, still it is not a settled law. But just a cursor to you, you can think in this line. You accepted the relief granted by the government. You got reduced your BG. You got your payment milestone reduced. You got your EOT. And still you are looking for underutilization and extreme unprecedented hike. So those things are yet to be settled. But I am not hopeful that those court will give judgment in favor of the contract.
Yeah, only issue is with bespoke contracts with private sector, where references are made to the government EOT and other norms. But the thing is, escalation for original contract period and for delays attributable to employer. See, now this particular scenario is not attributable to the employer. So during that escalation, and contract is made to work during that period, and escalation is not paid during that period, though formula exists, stating this is not a delay attributable to the employer. So there are peculiar scenarios arising out of.
You will get the escalation, and force majeure nowadays defined into three categories. It was being told by one. One is a political measure, political event wherein you will get full entitlement. One is the indirect political, whether you will get 50%. Another is in non-political, where you will not get anything. So you have to endeavor to qualify it as a political event where you are entitled to. And I have not heard any case, at least what we have dealt with several customers, wherein they have denied our right to escalation. And I am very much hopeful that whatever dispute resolution process is available in your contract, I don't think you will be denied with your right to get that escalation.
Sir, your name and organization, please.
I am Srinivas Mantri. I am heading contracts of capacity.
Thank you so much. Any more questions?
Mayank, one more question. Actually, this third-party funding, so for that also, the technical expertise is required to judge or merit the case, whether the case have a merit to fund or not. And the second question is, have you come across any case where due to change of government, particularly in India, in any state, the project is going on and due to change in government either closes that project or changes the project parameter specification drastically. So any such cases also you came across?
So the first one I'll take. On the funding, yes, absolutely correct. I think technical expertise on the entire dais was of the view that it will go a long way in terms of solidifying your claim and hence a funder backing you. I think on the government part, if
I can take that question actually. I have an experience where I was working on a claim and the claim majorly arisen because the government in a particular state changed, and I don't want to name the state and government at this stage, but the entire claim rested on that. Sir, your name and organization, please.
Abhijit Modak, heading subcontract in capacity infra projects.
I just want to add to the second question that was just put up. Contractually speaking, this is a problem not just in India but in politically vulnerable countries across the world, whether it may be Venezuela, whether it may be currently Israel, whether it may be France a couple of months ago. And this is the reason why in major infra and construction contracts, we must, I mean, a transactional lawyer must look at the stabilization clauses that need to be inserted in the contract. That if there is a change in the political scenario of the country, it should not impact the progress of the project. Of course, that's a longer discussion for another time, but just to give a glimpse of that.
Thanks, Kanika. I can take one more question, one last. Yeah, sir. Can we have a microphone here?
Hi, my name is Gopal Modi. I'm from Biking India. We construct smokestacks for power plants. Just a two-part quick question. One is to do with escalations and sort of a continuation. Can you be denied escalation? So we work with EPC contractors and our principal clients are generally PSUs. Can you be denied escalation if the escalation is there between the principal contractor and the EPC contractor and we have not got it in our contract? And the second part is there's been a scenario that the principal company has actually issued a notification that the COVID extension will be given to all EPC contractors, and currently we've not been passed on that benefit. So just what are your views, Kanika, or
Kanika, want to take that question?
Yes, I'll actually pass the mic on to Mr. Puran and Mr. Menon as well, because they'll give you a more commercial way of dealing with the situation. But the way we look at it is to check if your contracts are actually a back-to-back contract with the main contract. A lot depends on that. But when we talk about price escalation, if I had the chance to deal with that, I would definitely claim it. Granting price escalation right now is something which may not have been inserted in your contract, but that does not mean that you cannot ask for price escalation. There have been judgments in the past, various high courts as well as Supreme Court, where the price escalation was not provided for in the contract, and yet because of unforeseeable circumstances, that price escalation was granted. So the answer is yes.
Yeah, I mean what she has answered. One more thing just I will like to add there. That all preliminary depends upon the kind of contract you have entered with your main contractor. I mean it will go on by that, which you know very well. So even if it did not specifically covers, first of all it will go on by that. If you are able to bring within that provision, wonderful. Even otherwise you will be very much entitled to.
So can we approach the principal customer in the event that the EPC contractor is not passing on the benefit that's been actually given to them? In spirit, it's been given so that the subcontractors benefit from it, right? So it flows sort of down. But can we enforce it by approaching the principal in your experience?
No, we are receiving a lot of such communication, but to be very honest with you, normally I would answer that I am not a party to the agreement. So otherwise, even at the highest level, it is being undertaken when they make the principal employer also they make a party to that. And Kanika can throw more light.
Yeah.
I'll not waste anybody's time. We'll take it off the stage.
I'll just try to coherently speak on this. Is that it may not be in the best interest to actually approach a non-signatory at an initial stage when you're discussing this issue. What would generally happen is that you're going to approach the contractor under the subcontracting agreement, and then it is on that contractor's onus whether they want to go and claim this from the primary employer or not. Which may at a later stage, when the two arbitrations are concurrently running, may all be joined into one single arbitration. But really speaking, it cannot have a snowball effect. You will claim from X, that X will claim from Y if they want to claim from Y. But your entitlement to your claims does not depend on the success of X's claims on Y. I think this is where the mediating company always traps the subcontractor.
Can I have an extended question on the same?
Sir, I think so. There's one more hand at the back side. So let me first take that question. And ma'am, you have to be very quick in question, and so we need to answer it quickly.
Sorry, I'm not from the general, the posse of people sitting over here. I'm from academics. I'm Professor Aditi Prasad. I teach at Arjun K. D. Partli University, and I'm doing my PhD in MSME dispute resolution from Xavier Business School, Essex, UK. I have a rather offbeat question to you, sir. You recently stated, and from the gist of the discussion that basically ensued over here today, I can understand that the importance of expert witnesses and testimony is very important in course of arbitral proceedings. At the same time, it was also warily prodded that the need for having retired judges is very much important. Now, the two possibilities under the Indian Arbitration Conciliation Act 1996 for both of these accommodate happens to be either the appointment of the arbitrator under Section 11 of the Arbitration Conciliation Act, or Section 917 coupled with Section 27 of the Arbitration Conciliation Act, wherein you can have an expert witness or a testimony. Can you tell me, because of the lack of empirical data, on what exactly constitutes the preference, the corporate preference and attitude with respect to dispute resolution policy? Can you tell me what exactly is the expectation of the companies today, specifically in India, with respect to the appointment of the arbitrators? What exactly do you want? And if you want an independent arbitration expert, like Sir said, where exactly would you find the accommodate? Under Section 9 coupled with 17, which is the power of the court or the arbitral tribunal to give an interim relief, or under Section 11, wherein you want a technical expert. And at the same time, you also want retired judges, because there have been many of the reports from industry itself, like White and Chase or PwC, wherein you say that the retired judges are not suitable for the quality of the arbitral awards. And that's one of the reasons why India doesn't have a suitable, as a seat, it is not suitable. It is not under top 5 arbitral seats. The tactical advantage is not there, missing.
Your question is to?
To the sir sitting over here. It can be taken by the renowned arbitrator. I'm sorry, I'm very bad at remembering the names.
I will take that.
Okay.
So it was a very long question. So I will answer in 2-3 parts. So you were referring to the importance of this technical expert witness, asking you have to like petitioning to the court under Section 9 and 17.
So after the 2015 amendment, it has to be for the tribunal first. And if it is not possible, a convenient,
You see, the arbitration process goes like this. In any dispute resolution under any contract in India, it goes like this. There is a dispute which has been crystallized by a party. Then it goes through a conciliation process. The parties attempt for amicable resolution, right? Then, if it is not getting amicably resolved within a certain limited period, which is prescribed under the contract, then it goes for invocation of arbitration. Whoever is the claimant, they invoke the arbitration and appoints his arbitrator, nominates his arbitrator from any of the panel. As you said, what are the criteria for the appointment of arbitrator? The arbitrators are there in the panels. So many institutions have their arbitrators. Retired judges are there, technical experts are there. So many leaders of the industry are there for dealing with such arbitration cases. So the party decides. This may be an arbitrator who might be able to resolve it in an amicable and fair manner.
So why do you see, appointment of retired judges, the lack in institutional arbitrations which NHAI has? You said that the biggest problem in Sarod is that the retired judges are missing and they don't have, they only have technical expertise and they don't have people who could interpret the law. Why is there an overarching indulgence towards having retired court judges when it has been significantly pointed out from the industry itself that it happens to be one of the biggest glass ceilings why India doesn't have the tactical advantage as a seat of arbitration?
No.
That's what Sir was pointing out.
Whether India needs to be in the top 5 of the seat of arbitration, that is not the question here. The question here, India itself has, as he said, 1 lakh crores of worth of cases under one particular client itself. So India needs a seat for its domestic arbitrations. we are not there. We have to encourage the international disputes to come to India. India already has a lot of disputes in hand, and the seat of India is for dealing majorly for dealing the Indian disputes over here.
I wanted to know your preference in the dispute resolution policies.
Just a moment.
Ma'am, I would request, since we are running very short of time and the discussion is taking long, I request everybody to connect with the speakers when they're off the podium. Since we have been warned by MCIA to either close it or we'll barge in. So I'll have to close it now. And thank you everyone for coming, and I thank all of my panelists and speakers for their enlightening thoughts, and we would love to catch up again on similar events. We invite you all to a high tea session organized by MASIN just outside this hall. So please join us there, and please feel free to interact with our panelists and everybody available on floor. Thank you so much. Thank you everyone. Thank you the panelists again.